Today we're going to have a look at the defence of duress, and that's the most important thing that you need to take away from this presentation. Duress is a defence. So what we're looking at is when a threat has been made which leads to a crime being committed. This threat can be from a person, and this is duress by threats, or the threat itself can come from the circumstances, and that's duress by circumstances. So, the test for duress is that the jury must be satisfied, firstly, that the defendant was compelled to act as he did because he feared death or serious physical injury. So this is the subjective element. And also that a person of reasonable firmness with the same characteristics as the defendant would have believed this. So you've got the subjective element. Did the defendant feel that he was compelled because of the threat of death or serious physical injury? And you've also got the objective test. So the reasonable man would have also believed this. So first of all, let's have a look at duress by threats. And what we're looking at here is a direct threat of death or serious injury from an actual person. I mean, you can see it from the picture there that that's what we're having a look at. So when you're actually answering a question in the exam about this, you need to consider each of the following things, and you've got to address each one of them in the order that they are written. First of all, we've got to look at the nature of the threat, and that the threat must be made in connection with the offence committed. You can't have two separate things, so there's got to be a really, really clear link between the threat and the offence that is committed. The one has got to lead to the other. We also need to have a look at the characteristics of the defendant. We have to consider whether our defendant was intoxicated at the time. We need to think about the immediacy of the threat and the possible escapes, and also consider, was it self-induced duress? So there are various circumstances under which the defence will fail. If there was a safe avenue of escape, so for example, if the defendant should have gone to the police, then they won't be able to use the defence. If the threat was incapable of being carried out at the time that the defendant committed the offence, they also won't be able to use it. If the defendant is not told of the specific offence that they should carry out, then they won't be able to use the defence. So for example, if they are just told to get money, then they won't be able to use the defence if they have, for example, robbed a bank. And if the duress was self-induced by the defendant's membership of a violent gang, then they also won't be able to use the defence. So now we have to have a look at the nature of the threat. So the Graham test states that if the defendant feared death or serious physical injury, they may be able to use the defence. There's no defence if the threat is to damage or destroy property, although self-defence may be a possible defence. So this is the Graham test, and this is really, really important. So we have to consider, was the defendant compelled to act because there was a good cause to fear serious injury or death, so not damage to property? And if so, would a reasonable and sober person of reasonable firmness, sharing the characteristics of the accused, have responded in that way? So Hassan confirms the Graham test and says that it must be reasonable, and there's got to be a threat of imminent harm. So if we have a look at how this works in practice, in the case of Valderrama Vega, the threat was that the defendant would be exposed as homosexual, and the court held that this was not sufficient enough of a threat. It had to be a threat of death or serious injury, not, in his particular case, embarrassment, and therefore the defendant wasn't able to use the defence. So the threat must be made in connection with the offence committed. It can't be a separate thing. And so in the case of Cole, the defendant will fail if the threat was incapable of being carried out at the time. And the defence will also fail if the defendant is not told of the specific offence. So rob that bank would be sufficient, whereas get me money wouldn't. We also have to have a look at the characteristics of the defendant. You have to consider the effect that the threats would have on the reasonable man sharing the characteristics of the defendant. Now, this is discussed in the case of Bowen, and this is somewhat unpolitically correct. So the defendant in this particular case had a low IQ, and he'd been threatened that his home would be petrol bombed if he didn't provide various electrical goods. And the judge in obiter dicta discussed some of the characteristics that could be considered. So the things that could be considered were age, pregnancy, physical disability and mental illness. The judge also mentioned that possibly being female would be a sufficient characteristic. As I say, the judge's opinion and not mine. So we also have to have a look at the effect of intoxication. And in your exam you might see a combination of involuntary intoxication and duress by threats. And in that particular case you would consider both defences separately. So the next stage is we must consider that the threat must be immediate. And this is illustrated in the case of Abdul Hussein. In this case, there were 7 appellants who were Shiite Muslims from southern Iraq. Abdul Hussein had been sentenced to death in Iraq following a confession which had been extracted by torture. The other appellants were also fugitives facing death sentences in Iraq. They were living in Sudan and feared being deported by the Sudanese authorities. So they hijacked a plane bound for Jordan and landed it in Stansted Airport. After negotiating for 8 hours, the appellants surrendered, and at trial the judge ruled that the defendant's defence of duress of circumstances could not be put before the jury as there was a lack of requirements of immediacy. But then on appeal, the judge laid down the following test for immediacy, a 3-part test. So firstly, there must be imminent peril of death or serious injury. It must be on the defendant's mind, but the threat doesn't have to be executed immediately. It just has to be imminent, it has to be soon. It must be on his mind, and the threat must be of death or serious injury. So we now have to think about self-induced duress. So the way that the courts view it, and this is very much a policy decision, if a defendant voluntarily associates people who are violent, then the defence will not succeed if that violence is then used. If the defendant knows full well that these are violent, bad people, then he will not be given a defence. So in the case of Sharp, the defendant was a member of a gang, and it was decided that it was self-induced duress as he got himself into that situation. He'd been involved with a plan with a gang to commit a robbery, and he'd tried to withdraw from that plot, but he was threatened, and somebody was killed during the robbery, and his conviction for manslaughter was upheld. The Court of Appeal had made it clear that the defence would fail where the defendant knew that the gang he had joined might put pressure on him to commit an offence. And clearly, the question is whether the defendant should have known rather than whether he did know. And in this particular case, it was quite clear that he should have known that there was this real risk. So now we need to have a look at duress of circumstances. This is still a threat of physical harm, but the threat doesn't come from a person, it comes from the circumstances that the defendant found themselves in. And this actually happened to David Beckham, the footballer, in 1999. In 1999, David Beckham got an 8-month driving ban for speeding in his Ferrari. At the time, he was 24 and he was found guilty of doing 76 miles an hour in a 50 mile an hour limit. He argued that he didn't choose to speed, but he was speeding because he was trying to escape from the paparazzi who had been stalking him for the past 10 miles. He argued that going at that speed was the only way that he would get away from this without there being an accident. He tried to use this defence, but he was unsuccessful because the court claimed that it wasn't the only option available to him, that he could have avoided this situation. It's also worth mentioning that he'd already got a previous 10 points on his licence, and there's no suggestion that they were due to the threat from paparazzi. Now, historically, duress of circumstances used to just be usually for driving offences. I had to drive at that particular speed. I had to drive whilst I was over the limit because I had no choice. But now it's been opened up to other offences as well. So if we have a look first of all at the case of Martin, this is a case from 1988, and he drove his son to work whilst he was disqualified. He argued that his son might lose his job if he were late, and his wife had threatened to commit suicide if he didn't take him. And the court confirmed that English law recognised a defence of necessity in these sorts of extreme circumstances, so he was allowed to use the defence. In the case of DPP and Bell, the defendant drove whilst he was drunk to escape a threatening gang, and the defence was successful because as soon as he was out of danger, he pulled over, so he was allowed to use the defence as well. And if we have a look at the case of Pommel, this demonstrates that the defence isn't just limited to driving offences. So the defendant was charged with possession of a firearm and successfully argued the defence of duress. He said that he'd taken the gun from someone who was threatening to use it in a revenge attack. As this was in the early hours of the morning, he kept it overnight, intending to take it to the police station in the morning. However, the police arrived before he was able to do this, and he was also able to use the defence. People quite often get confused between duress and blackmail, so I want you just to take a moment to review your notes and refresh your memory about the two separate things, and I want you to make up a list of the similarities between the two and the differences. So pause the film here and have a think about that. So I'm hoping that you've paused and that you've thought and you've come up with a list of similarities and differences. So in terms of the similarities, the key thing is that one party makes another party do something against their will. But actually there's not a lot more to it than that, and that's almost where the similarities end. If we look at some of the differences, duress is a defence to having committed a crime. So you need a crime to be committed first before you even think about duress, whereas blackmail is the offence in itself. In duress, the person has committed a crime that's not murder or attempted murder, and in blackmail, the person has either lost money or the defendant has gained money as a result. With duress, there is no necessity for money to be involved necessarily. And finally, in duress there must be a threat of death or serious violence, whereas in blackmail there must be a demand with menaces. So those are the main areas of differences. And when you see it like that, you'll see the similarities, although on the face of it they do seem quite similar, that is where it ends, making somebody do something that they don't want to do, whereas the differences are quite stark. So finally, I'd like you to have a read of this scenario and I'd like you to attempt it. We're looking at Fez, who has a reputation for violent conduct, and he envies Luke's apparent wealth. Fez threatened Tom, who was a 17-year-old boy who occasionally worked for him, that he would end up in hospital unless he stole property from Luke. Later that day, Tom saw Luke in the street using a mobile phone, which Tom violently grabbed the phone from Luke's hand and ran off. What I'd like you to do is discuss the possible criminal liability for Tom in connection with the mobile phone. I want you to think first of all about the offence, which in this case is theft and robbery. And then I'd like you to have a think about the defence of duress by circumstances. Remember, the key thing is you must always establish the offence before you think about the defence, because if there's no offence there, then there's no need to consider a defence. Make sure you don't take any more than about 15 minutes actually writing it up, but use your notes the first time out and make sure you get all the elements in.